Case number 110573, Kansas City Power and Light v. Strong et al.
May it please the court. My name is Dan McLean and I represent the appellant Kansas City Power and Light Company. I respectfully request to reserve 5 minutes of my time for rebuttal.
5 minutes is granted.
This is, as you know from our brief, an eminent domain case, and it's a partial taking case. Kansas City Power and Light is building a new power line in Miami and Johnson counties. The line is between 8 and 9 miles long, and Mr. and Mrs. Strong owned 2 adjoining tracks along the project route. And when KCPL wasn't able to acquire easements from them by agreement, the company had to exercise its power of eminent domain and take the easements. The easements taken were 70 feet wide. The 2 Strong properties total about 460 acres, and the total easement area taken by KCP&L totals about 12.86 acres. At the time of the taking, there was a lot of evidence at trial about what the highest and best use of the property was. But at the time of the taking, the facts are that the properties were being used as farmland. They'd never been platted.
But that's a little inaccurate because your own appraiser, Laird Goldsboro, testified that farmland was worth $3,500 an acre, straight farmland. But he testified this land, the north tract was worth $8,300 an acre, and the south tract was worth $7,300 an acre, over twice the farmland value. So the highest and best use was not only farmland, but it was also holding as investment property. Wouldn't you agree?
That's correct, Your Honor. I guess my statement was more to how the property was being used.
Well, it's being used, but that's different than the hiest and best use.
Oh, I agree,
I understood you to say the highest and best use was farm ground, and that's not true according to your own appraiser.
No. If I misspoke, I apologize. But what I meant was that the property at the time of the taking was being used as farmland, right?
And if you agree with me that the highest and best use was to hold as investment property, wouldn't the real question here be if it was worth $8,300 or $7,300 an acre without the power line, without the easement being in place, what would an investor pay for it if the power line would be there? Isn't that really what we're talking about? Is what the value would be after, and for an investor today, not I agree with you, the 5 or 10 years down the road is not what we look at. But if I were going to buy a tract of land to hold for investment, I would pay more if it didn't have power lines than if it did. I mean, I think most people would. Would you agree?
It would depend on well, it goes to the question of fair market value, right? Fair market value before and after, and it depends again on what the use of the property is and how you value it. And I guess, this property at the time of the taking, it did have speculative potential. That's true. Our appraisers acknowledged that, but it was being used as a farm, and it hadn't been platted for residential use. No one was planning to do that. Hadn't been zoned for a dense residential use, and it didn't have utilities.
Am I correct that the jury essentially adopted your position with respect to, or at least one of your experts' position with respect to the pre-taking value? That would be, I think it's Mr. Jaggers, is that correct?
Yes, Mr. Jaggers. That's correct. The pre-taking value, they...
So are you still, does any of your appeal relate to the district court's evidentiary rulings with respect to pre-taking value?
It does not.
Okay.
We're focusing on the real objection and the heart of the case relates to...
Well, I understood you to begin your argument here talking about pre-taking value.
Oh, right.
But I may have misunderstood that. That's why I asked for clarification.
again, was talking about the use of the property at the time of the taking. The heart of the appeal, the heart of our complaint goes to the evidence that the Strongs were allowed to offer about how the property should be valued after the taking. And what they essentially did was say the highest and best use of the property would be as a residential subdivision, right? And then they created a concept land plan depicting the farm ground as a subdivision. Before the taking, this fictitious subdivision had 1,300 plus lots, and after the easement was in place, the subdivision had fewer lots. And so what the Strong's experts did was take this concept land plan and basically say that KCP&L's easement had hurt the subdivision in a couple of different ways. One way was that a developer would have to discount the lots that were abutting KCP&L's easement. And what the Strong's experts said was that each of those lots would have a value of $50,000, but because those lots abutted the easement, they'd have to be discounted by $30,000.
Why isn't that just evidence of what the fair market value would be? The evidence that the jury could buy or not buy.
Right. It is the idea that lots abutting the easement might have to be discounted by a developer. That concept is, that is relevant information. The problem that we have is the values that were placed on it, right?
So let's distinguish between an objection to the admission of the evidence versus an objection to the essentially the veracity of the evidence. I mean, if your objection is you don't object to this kind of evidence being put before the jury, you just think it was wrong. I mean, why isn't that just a battle of the experts, essentially? And you had your experts that could have contested that valuation. Right.
The reason we're objecting is because of the Kansas statute specifying how fair market values should be determined. And that's 26.513E says fair market value shall be determined using one or more of the three specified appraisal methods. And the method that the Strong's experts used to calculate, for instance, the lot discount prices didn't use any of those methods. That's what the objection is.
Well, they used the methods to get to the pre-taking value.
They used the methods that...
Comparable sales to get to the pre-taking.
Yes, Your Honor.
And then they had to determine what kind of damage was going to be done and how that would damage fair market value.
That's correct. They then had
And it seems to me that if I were in the market to buy this land with and this land without, the without would look more attractive because I would have more to develop. More potential development than here, and that's basically what they were trying to show, or what the developer was testifying to, is I have to discount these lots and I have to leave a wider space for the fall, allow the lines to fall and that kind of thing. And it was really explaining why a developer would pay less after that's in place.
That's correct. That's what the testimony was. And in the abstract, that type of testimony about here's what a buyer would consider is okay. The objection that we have is then putting dollar values on this and using a method that does not comport with 26.513E, which specifically says to determine fair market value after, you use three methods. The Strongs didn't use any of those methods, and their experts said they weren't using any of those methods. They were just putting value evidence into the record that wasn't tied to what the statute says you have to do.
And how would you have applied one of the three methods?
Just, may I interrupt? The statute also says any combination of the methods.
That's correct.
Okay.
That's right.
Sorry.
Right. You can apply the methods, and it's been done under this court's cases that use...
No, let's put it in this case. In this case, we're trying to determine, or the jury's trying to determine, the diminution in value that the power line would impose. And how do you get comparable sales, for instance, to give you a number on the damage?
Well, I mean, you could go get comparable sales by, that's one method you could use. I don't know how exactly an appraiser would do that, but the Strong's experts could have done that. And they also could have, Your Honor, used the income approach. I mean, which is authorized by the statute. And you know, that would be a proper vehicle for getting this type of value evidence, these numbers into the evidence, like they did without using one of the methods. And the court's decisions, prior decisions, they are somewhat dated. You know, State Highway Commission versus Lee, and also the Kaiser Living Trust case, they talk about something called the development approach, right? And the development approach would, if these dated cases are still viable, that would allow you to take raw farm ground, just like the Strong properties, and then treat it as a subdivision and take the selling price of the lots and deduct the development costs and measure the effect of the taking that way. That was theoretically available to the Strong's experts, but they didn't use the development approach. The district court actually believed, I mean, in his statement about why he was overruling our motions to strike and motion to preclude, said he believed that this court's precedents allowed the development approach. The district court believed that's what the Strong's experts were using, but they weren't. So I think that answers your question, Your Honor, about how it could have been done. What they ultimately say what the Strongs say that they were doing wasn't using any of the three methods. Those experts admitted that they weren't using the cost approach or comparable sales approach to reach the after valuation. What they say they did was they used the comparable sales approach to reach an after value, and then they made a, quote, statutory adjustment. And remember, they assigned values saying, well, the property's been damaged because we have to discount lots next to the easement by a total of $2.76 million. The property's been devalued because the increased land cost per lot has gone up, you know, $920,000. That's what they wound up doing. And what they said was, we basically took those numbers and just deducted it from an after value arrived at by comparable sales. And they argue that they're permitted to do that by a different part of the statute, which is section 26.513D. And our position is that you can't use 26.513D and those statutory factors to basically create a new method. You have to read all aspects of 26.513 together. And the way you do it is a very sequential process. 26.513C says that in a partial taking case, the amount of compensation and measure of damages is the difference between the fair market value of the entire property immediately before the taking and the value of that portion of the tract remaining immediately after the taking. And then 26.513E defines fair market value and says, and I'll just quote it, the fair market value shall be determined by use of the comparable sales, cost, or capitalization of income appraisal methods or any combinations of such methods. And then this provision that the Strongs rely on is in 26.513D, and it says that in ascertaining the amount of compensation and damages, this following list of factors shall be considered if they are shown to exist. But those factors are not to be considered as separate items of damage, but are to be considered only as they affect the total compensation and damage under the provisions of subsection C, which goes back to the fair market value before and after. And our position is you can consider those factors. In fact, you have to consider those factors, like the most advantageous use of the property to which the property is reasonably adaptable. You should consider those, but you can only do it in the context of an authorized appraisal method, right? And
isn't that though what at least Mr. Smith testified that he did? Didn't he testify that he used I think the comparison method and then went to those statutory factors to apply adjustments?
I think what Mr. Smith acknowledged is that he hadn't arrived at his valuation using any of the three authorized methods, right, in the after value.
Well, he may have said that. I don't know, but let's drill down a little bit. My understanding, and correct me if I'm wrong, is that he testified that he started with a fair market value using one of the methods and then applied adjustments.
That is what the Strong's methodology was.
And isn't
correct.
that also what KCP&L's experts did? Didn't they also start with a sales comparison method and then apply adjustments also?
Yeah, the vast difference between those approaches. Appraisers using the comparable sales methods do use adjustments to account for location, the size of
Right.
the property and things like that.
I understand there's a difference in the numbers. That's why we're here.
Right.
But how is that method different?
Yeah, their method is different, Your Honor, because what they did for an adjustment was to use lost income, right? And you can use lost income. You can use income to help determine the fair market value of a property, but you have to do that in the context of the income appraisal method authorized by the statute, which is not what the Strong's experts did.
And what's your authority for that proposition, that they misapplied the statutory factors in, is it subsection D of 513?
Yeah, you're right. Subsection D, Your Honor. Probably the thing to do is say that there is no Kansas case that I could find authorizing this method, right? There's the development approach cases that would allow that approach to do evaluation. The authority, and there are other cases like Creason and Denton that talk about you can bring lost income or income into evidence, but only in the context of an income appraisal approach.
But I didn't understand, excuse me,
Go ahead.
I didn't understand that he was saying that they were losing income, as in generating the income, but that the value was going to be reduced because they couldn't sell as many lots and some of them wouldn't bring as much. So when I look at buying a piece of ground to develop, I need to look at how many lots I'm going to get and how I'm going to recoup my money. And so the value of that, the sale price that I would be willing to pay would be reduced because I couldn't recoup my money. It wasn't a capitalization of income, which is the income method where you take the income and apply a rate of return and turn that into a market value. It was I can't afford to pay as much to develop this because I'm not going to be able to sell as many.
Right. Your Honor, the adjustments that they made actually are lost income, right? Because if they are deducting from the purchase of the price of the property $2.76 million, because that's how much a developer would have to discount the lots by, the lot discount of $2.76 million is lost income to the developer.
I understand that, but that misstates what the income method is. The income method is really a capitalization of income, kind of
The
thing.
landowner's
Yeah,
income, current income from the property.
Right.
I'm not sure I understand the question, if there is one now, but.
Well,
but-
in other words, you're saying that's where the flaw is, because they were talking about income to the developer rather than this capitalization of income to the landowner.
Right, they are measuring the damage to the property by lost income without using an income capitalization approach,
Okay.
before or after. Your Honors, I see I'm out of time. To the extent I haven't covered everything, we rely on our briefs.
Just one quick follow-up question that you brought to mind based on your last statement.
Yes.
Why, assuming they did what you say they did, which is make an income adjustment without utilizing that method, the statute does allow, however, for the combination of these methods. So why doesn't that, even if you're correct that in your argument as to what the landowner's expert did, why isn't that allowed?
Yeah, they could have. We go back to the idea, Your Honor, that their adjustment that they made was based on income or lost income, but didn't use any method to calculate fair market value, if that makes sense, in the after condition. Did I answer your question?
Yeah, I think so.
All right, very good.
Any further questions? Thank you, counsel.
May it please the court, John Duggan on behalf of the Appalese Cross Appellants, Dan and Evelyn Strong. I think the discussion with KCP&L's counsel focused the issue, and really the issue was all the appraisers gave before values, and the jury adopted one of KCP&L's appraisers, Jaggers, before values. They're highlighted in yellow. And the before value that Mr. Jaggers came up with on the north track was $11,000 an acre. On the south track, it was $10,000 an acre. Every expert in this case testified that before and after the taking, the property could be used for ag value, which was $3,500 an acre, uniformly across the board. The investment premium, the difference between farming the property and having some return for being in the growth pattern, was essentially, according to the Jaggers testimony, $1,072,000 on the north track and $2,060,000 on the south track. We talked about it during the trial as essentially a $3.1 million investment value. There was no dispute. Every expert that took the stand in this case agreed that this property was worth more than farmland. And the key issue was what Justice Johnson focused in on the previous discussion, is what kind of an impact did the power line have on the $3.1 million to a well-informed buyer. And the jury instructions and the statute were very clear. What would a well-informed buyer take into consideration in making a determination in what to pay for this property? In fact, KCP&L's counsel fronted that to the jury in opening statement by saying, this property is ag land for speculative holding, and this property today, quote, has development potential, and at some point down the road it might become a different kind of use, like a subdivision. Their counsel went on to say, highest and best use in opening statement is the most advantageous use of the property. They went on to front Mr. Lambie's opinions in their opening statement, saying that Mr. Lambie is going to tell you that as a developer, the developer's not going to pay for this premium any longer because it's been diminished. In their opening statement, they put up the conceptual land plan that Mr. Lambie had developed to explain to the jury why the property was less valuable after the easement was taken. All of the things which they later on would claim were objectionable and shouldn't have been heard by the jury. More importantly, they said, we have our own development expert. And they really tried the case on a development or on an expert witness credibility battle, and they lost. They fronted to the jury that we have our own expert, Mark Simpson, who's going to testify that this property is not burdened by the power line easement afterwards, and at the most it's been diminished as $128,000. Yet Mr. Simpson never gave that opinion at trial. All he did at trial was confirm what Mr. Lambie and what Mr. Smith and the other 5 developers in the case testified to. And keep in mind, there were 6 developers that were either consulted or testified live in this trial. Every single developer unanimously agreed that if you're going to buy this property after the easement is taken, you have to account for the density reductions caused by the power line because you can't get as many lots, and you have to account for the reduction in the sales price of those lots adjacent to the easement because the view is unattractive. You've severed the property, you've run a power line right through the middle of it that's 5 to 7 stories tall.
And what method did your experts use in determining what that degradation was?
They used, in their opinion, the statutory adjustments that you should make to comparable sales. Mr. Lambie's comparable sales, $15,000 an acre, was not accepted by the jury. Mr. Lambie was specifically asked at trial, as was Mr. Smith, what, in your opinion, of this $3.1 million investment value was impacted by the easement? Mr. Lambie's testimony on volume 8, page 307, lines 18 to 24 said it's been wiped out. It no longer exists. As a developer, investor, the $3.1 million that comprises the investment value as testified to by Jaggers is gone. In my opinion, no investor developer will pay for that. What Mr. Lambie did then was to go on to explain to the jury how he reached that conclusion. And what he said to the jury was, in my experience, you have to have a fall zone away from these tall poles. If you want to get a look at what these poles look like, they're Trial Exhibit 219 in our appendix. There's a garage that's adjacent to one of the poles that you can see. It's a one-story repair garage, and you can picture the size of these poles, and there's a car driving next to it, which looks tiny compared to the poles that were going to be used. And Mr. Lambie says you couldn't sell anything within the fall zone because people are not going to want to be in the fall zone. KCP&L called Johnson County planning person to the stand who said, we have a statute that for the similar cell towers, you have to have a fall zone equal the height of the pole both sides. So Lambie said, you got to have a fall zone. I have to count for loss of density. And what he did is what every developer in this case said they would do. And that is go through and come up with a schematic to how to best deal with the easement. I'm going to make a $4.7 million investment. And I don't care if it was a $1.7 million or a $6.7. Every developer goes out and says, I've got to see how I can fit this community together, with or without a power line. And so what Lambie said is, I did that here. I do what I always do whenever I evaluate a land purchase. I come up with a schematic plan and I evaluated density before and density after. And I'd have to make an adjustment downward in the Strong's price because I can't get as many lots on the property. I also, as a cost
And so
of...
what category does that fall in?
I think it falls into A, what a well-informed buyer in the agreed jury instructions, the jury was told, what adjustments would a well-informed buyer make? One of the adjustments, the only adjustments that well-informed buyers, the 6 developers that were consulted in the case said was, I got to account for loss of density. And so what I'm going to do...
But how did they value that loss of density? What method did they use to value the loss of density?
Number of lots before, number of lots after the easement is taken.
Was that still a comparable sale?
Yes, I think it's a
Did
comparable
they
sale.
bring in comparables?
Pardon?
Did they bring in comparables to say lots with this type of pole sells for this?
No, there is no such evidence.
So how can it be comparable sale?
Because you start with comparable sales and you have to make adjustments.
Right, but how do you value how did they value the adjustment?
Just like they have in every other case, the experts gave their opinions about what the value of the adjustments need to be. Keep in mind, and this is important, this is the same methodology that KCP&L's experts used. If you look at Trial Exhibit 56A in the record, KCP&L expert Goldsboro said, in my opinion, a farm that sold 2 miles east of the Strongs on 183rd Street is worth $3,800 more per acre because I think it's a better location. And he made a $1.75 million adjustment to that comparable sale based solely on his opinion that he thought it was a better location. That's what the experts in this case did. Except my experts actually told the jury, here's the methodology that I'm going to use because it's been testified to by 6 developers in this case, including KCP&L's expert Mark Simpson. This is what developers do in demanding discounts for properties that will have a power line easement. This is not an income approach. It's an adjustment to a comparable sale. The Strong's property before the easement was $4.7 million. The whole decision for the jury was how much of that investment premium of $3.1 was impacted by the easement. What our experts said was, if I can buy a property across the street from the Strong's for $4.7, and I have to spend a lot of money, in my developer opinion, expert opinion, to deal for and account with the cost of doing business on the Strong property because of the adverse impact by that easement, I'm going to deduct it all the way down to the point where I'm willing to accept the risk of buying the property with the easement on it so that when I get done spending all the money I have to spend to get back to equilibrium, I'm equal with a property that does not have the easement. And what they did is they went through, in their expert opinion, the adjustments a well-informed buyer would make for loss of density and the discounts you have to offer to people to entice them to live next to a power line because of the appearance and the view. 2 statutorily authorized adjustments that can be made under 513D. So essentially what my experts did was to say, we've consulted Mr. Burrows, Spolito, Lambie, admissions by Simpson. All developers agree this is how they go about pricing property that has a power line easement in it. We didn't ask for any income above 4.7. All we asked for was the costs that were going to be incurred by a well-informed buyer to make this site back to equilibrium. They had to spend money to do it. They lost density. They were going to have to discount lots. The point being, and I think this is really important, this issue is really one that I think has surfaced on appeal, and I really found fascinating the earlier discussion in the earlier case about preserving it. We've taken the position in this case that this whole issue was waived by KCP&L. And I want to speak precisely about this because I think it's very important. What occurred was Mr. Lambie testified at trial. KCP&L did not object to his trial testimony. They began their cross-examination, and shortly after they started their cross-examination, they moved to strike his testimony in totality. And Judge Gurney said at that point in time, I think I'm going to wait to hear the rest of the evidence to make a determination on whether or not we're going to strike any part of his testimony or all of it. But the request at that point was, I want an instruction to the jury that says Lambie's testimony is out. That was the requested relief. Mr. Smith took the stand a day and a half later, and when Mr. Smith took the stand, they wanted to exclude him from testifying because he relied in part on Mr. Lambie. And Judge Gurney brought up the point after it was raised by KCP&L's counsel. KCP&L's counsel said, well, Judge, I want to renew the discussion about striking Mr. Lambie's testimony. And at that point in time, Judge Gurney said, okay, I understand that. And here's what Judge Gurney said on the record. He said, some of this is dependent on how much of a record you want to make. This is volume 9, page 174. Judge Gurney said, I can't tell specifically because, again, you made an objection, and it was pretty broad objection. I would not expect there would be any dispute that a lot of his testimony would not be objectionable in terms of the scope and the relevancy. However, I don't know. It's for you to make the objection. I think the thrust of your objection wanting to strike was not necessarily his entire line of questioning. Mr. Kennard, counsel for KCP&L, that is correct. The court, but dealing specifically with some of the valuations that he placed. Mr. Kennard, you hit the nail right on the head, Judge. Mr. Kennard, quote, as far as his knowledge of sewers and whatnot, I don't care. They waived the objection and the request for instruction that all of his testimony be stricken. They told Judge Gurney that in the middle of the trial. They never came back to Judge Gurney ever again with a request for a jury instruction asking Judge Gurney to actually instruct the jury that certain portions of Lambie's testimony be stricken. And in fact, KSA 60-251 says that once the trial commences, if the jury instructions presented to the trial court are insufficient or there's matters that arise during trial, that you must request an instruction from the trial court on the relief requested. And under 60-251C, a failure to request that instruction waives the issue. In this case, Mr. Lambie had testified on a number of different subjects, from housing growth to sewer formation districts to the pattern of growth to all the development activity going on around my client's property. And he gave his opinion, his global opinion that said, I think those investment values have been wiped out. That's what Mr. Lambie said. There was never a new instruction requested by Judge Gurney. There was a waiver of the first request that said we want everything wiped out, and it was admitted to on the record by counsel. But there was never a request to say, you know what, I want this portion of Lambie's testimony stricken. In fact, KCP&L submitted agreed instruction number 9 to Judge Gurney. And they told Judge Gurney in agreed instruction number 9, we give this instruction on how to evaluate the credibility of the expert witnesses, which essentially said you must evaluate what their opinions using your common sense. Never did they request that instruction number 9 be amended to in any way limit Mr. Lambie's testimony or Mr. Smith's testimony on any of the claimed objections. They fronted the issue in opening statement. They prepared agreed jury instructions to Judge Gurney. In the agreed jury instructions that they submitted to Judge Gurney, they said, we want the jury to make a determination as to what the burden under instruction number 14 was to the remainder by the easement. Ladies and gentlemen of the jury, you have to determine the burden to the remainder. Instruction number 15 will ask the jury to make a determination as to the most advantageous use of the property.
Can I just interrupt you there?
Yes, please.
I'm going to ask a clarifying question that's really not in the line of your argument, but you talked about the burden to the remainder. As I'm thinking about this here, is there any, from your perspective, is there any dispute as to the value of the remainder prior to looking at the burden? In other words, is that just a factor of subtracting out the number of acres that the power line covers?
No, because when you evaluate the damage to the remainder, you have to go through.
I understand that, but before you get to the damage, in other words, you got to have two numbers. If you've got a damage to subtract from, what number do you start with?
You start with the value before there was ever
The
a
value
condemnation.
before has no power line, so you take all the acres.
Correct.
And I may just be wrong here, that's why I'm asking you to help me clarify. Is the remainder the number of acres that are left after you take out the actual acres that are covered up with the power line?
No, because in this case, we still had rights to possess the easement. KCP&L made the pitch to the jury. You can even still plant crops underneath of these power lines after we take them. All we're taking the right to do is pass across the property.
But we know you can't build a house on it.
Well, precisely, and that was our contention, but their contention to the jury was it's still ag, it can still be used as
But
ag.
as I understand your argument, it's that your clients were damaged not just because we can't build houses where the power lines are, but the power lines actually, in your words,
Degrade,
further harm or degrade the remainder.
Correct. They
Okay.
burdened the remainder beyond just the physical parameters of the 70-foot
That's what my question was.
There's two categories of loss, basically, two categories of loss, actual acreage and then what it does to the remaining acreage.
Our contention was it was simply the damage to the remainder because even the 70-foot wide easement was incapable of satisfying a fall zone. Yes, Justice Johnson?
You have two categories of value. It doesn't harm the farmland values, but it's the investment premium is where you're applying the.
I don't think there was any
damnation
dispute by
value.
any expert in this case that $3,500 an acre farmland value had been no impact on it by this easement because you could still farm under it.
Well, but it does cause damage.
It causes-
just doesn't. You just don't lose the 12.5 acres.
Correct.
Yeah.
The damage was to the investment premium. And what we pointed out, and I think the reason why the other statutory factors that were agreed to in the jury instruction number 15 were the productivity of the property remaining. And we argued to the jury, the productivity of the property remaining, the entire productivity of this property was the fact my clients had soaked their life savings into these farms over 20 years ago. And they were waiting for the growth to get to them. And just when the growth was about ready to overtake them, they had an easement imposed on them and they lost their investment value. The point being is that there was a lot of discussion at trial, and KCP&L's experts lost the credibility battle in part because they came to the trial and they weren't informed. There was an $8.6 million purchase by Block & Company about a half a mile north of my client's property to put in a mixed-use commercial. The city of Olathe approved a vast sewer district right across the barbed wire fence from my client's property and spent tens of millions of dollars installing those sewers. Water District Number 1, another government utility entity, had spent and was spending tens of millions of dollars to build a 60-inch water main on 175th Street. Developers were forming a sewer district just to the west of my clients at the southwest corner of 175th and I-35. There were 3 residential subdivisions surrounding my client's property. Their experts didn't take any of that into account when they came to trial. And what they told the jury was, oversimplified, here's my conclusion, none of those statutory factors have anything to do with this. Ladies and gentlemen, it'll take 75 years for this property to be developed, when they didn't know some of these basic facts about what was going on around the Strong's property. Ladies and gentlemen of the jury didn't buy it. because most of them had lived in Johnson County their whole life and had seen the county grow right down I-35. And they understood when Mr. Lambie made that presentation that this property was being prepared to be overtaken and that that investment value had been destroyed. And that's why they came back within the range of damages that were bracketed by KCP&L's experts, not mine. Thank you so much for your time.
Do you have any more questions of council? Thank you, council. You reserve 5 minutes. Council, you can take your exhibit down if you care to see the court.
Your Honors, I'd encourage you here in our appendix, we included photographs and maps showing what the property looked like and the character of the property. And we also, in the appendix, included this subdivision land plan that their expert used to calculate the damages in the after condition. And I'd encourage you to look at that because there was a lot of discussion about at trial about, well, the sewers are coming over here and there's a subdivision, coming right over here. But if you look at the photographic evidence, it really shows you what this property looked like. And that the subdivision land plan that they used, which is in the appendix of Exhibit A4, another piece of evidence that came out from their experts is this isn't going to be built out tomorrow. It's going to take about 15 years to build out, maybe 20.
But we've already conceded, or you've conceded, that the value of this land included and what the Strongs are referring to as the investment premium, that it did include a component in its value that involved more than farm ground. It involved the potential of a development in the future.
I think what I conceded is the property was for agricultural purposes and for speculative holding.
Well, Goldsboro said it's worth $8,300 and $7,300 respectively, and farm ground was $3,500. So he included a premium in the value that was investment purposes.
Right.
I mean, the only reason to pay more for farm ground is if you think it's going to be worth more in the future for some other use, right. Correct? Right. And so my question is, how do you determine the damage or diminution to that value caused by the power line if you can't lay it out on paper and say this is what it's going to do to a developer? How do you come up with the value of what a arm's length transaction would generate for a purchase price?
Right. You use the statutory methods.
Well, tell me specifically how you have to go find a comparable piece of ground that's got a power line across it.
Your Honor, I think what Judge Gurney thought that they were doing would be a way to value this property in the after condition, right? And that would be to use the development approach, use a subdivision plan like they did, right? Put lots on it, and then calculate, use appropriate discount factors for the 15 years it's going to take to build out all these lots, the development costs for putting in streets and things like that, and to calculate your damages on that basis. It could have been done that way. This is not the method that the Strongs used.
Well, why isn't it? Because, as I understand it, there's a cost comparison method that's accepted by everyone to get to a before value. And then your position is that your experts came in and testified. We used the cost comparison method to also arrive at an after value, and it's basically just simple math. We say the acres are worth this. We used cost comparison to arrive at a per acre value, which does include an investment premium, and then we just subtract. We just say 12 acres or whatever the amount is, and we just subtract it out. That's boiling it down. That's KCP&L's position, right?
Using comparable sales.
So we have a after taking cost comparison method of a per acre value, right? And so why isn't the landowner then entitled to say, taking from that post-taking cost comparison fair market value, we're entitled to make adjustments for the additional damages caused by the ground, which the power line doesn't run over.
And it's because of the adjustments that they made, right? And you
So again, I go back to a question I asked you when you were up the first time. Your objection, it seems to me, is really it's not to the method, it's to the adjustments.
because the adjustments are part of the method and no method was used, right? I see what you're saying, Your Honor. They used comparable sales and they made an adjustment, right? Just like you adjust for location, they tried to adjust for damage to the property because they couldn't put lots there or whatever. And I guess our point is that what they're really measuring there is lost income, and there is a way to measure lost income in the statute, right? But it's not what they did. They didn't use the methods.
Thank you. That I understand your position.
All right. And I did want to go back to my point. Well, I'm out of time, Your Honor. So
I'll give you 30 seconds to wrap up.
the objections that we made to these experts were they're not using an authorized method, and 26.513E is black and white about the appraisal methods you have to use. And the other objection we made is that it's speculative, because if you are basing your damages on a subdivision with over 1,300 lots that you admit isn't going to be built for 15 years, we felt like that basis for calculating damages was inherently speculative. And I think that's evident on the face of the admission that this subdivision, when it gets built, might not even look like this land plan that we've used to calculate our damages. With that, we submit the case on our briefs, and thank you, Your Honors.
Any more questions? Thank you, counsel. We thank you both for your arguments this morning and looks like this afternoon. Court will take this matter under advisement. That concludes